Good morning, everyone. This is Al Parsai, regulated Canadian immigration consultant, live from Toronto, Ontario. We're going to talk about the latest development in the world of immigration to Canada. And of course, if you have any questions, I'd be more than happy to answer those questions to you. Just to introduce myself, I am, as I mentioned, a regulated Canadian immigration consultant. I represent clients in their immigration matters, work permits, study permit, visit visa applications, ETA, resolving immigration issues such as inadmissibility, removal orders from Canada. I deal with certain immigration hearings like appeals of sponsorship applications, appeals of certain removal orders, dealing with residency obligation issues, refugee protection, division hearings, and so on. I'm also the author of the bestseller book, 88 Tips on Immigration to Canada. You can purchase this book from any Amazon website or visit 88tips.ca to find out your purchasing options. And it's available pretty much all over the world. People buy it from all over the world. And just a little bit of news. I have been appointed as an adjunct professor at Queen's University, one of the top-notch law schools in Canada. I'm also a professor at college, at Ashton College in Vancouver, Ontario. And that's pretty much it about me. Now, in terms of what is going on in the world of immigration to Canada, and by the way, if you have any questions, just post them in the chat area. And when I'm done with the news, I will answer those questions. By the way, if you want to find out our latest news on the website, you can just type in settler.news. I also put this here. So settler.news. If you type in settler.news instead of settler.ca, it will take you to the news section. We have recently hired a journalist, Andrea Nira. She's really good and she publishes the latest updates under settler.news. So you will see, actually, if you are following us, you probably have noticed starting from last Monday, we've had daily updates about immigration to Canada on top of my articles. So you see my articles, but you also see the latest updates about immigration to Canada. And most of those updates are written by um, Andrea. And also because she knows Spanish very well, she also publishes them in Spanish. Okay, so in terms of the updates in the world of immigration, the first one is about Hong Kong residents. The government of Canada has decided to create two streams specific to Hong Kong residents to assist them to become permanent residents of Canada. The first stream is that you need to be a Hong Kong resident. It's called Stream A in Canada graduates. You have valid temporary status in Canada. You are physically present in Canada. You intend to live anywhere in Canada but the province of Quebec. You need all the language requirements, and by language requirements, I mean you are CLB 7 or Canada Language Benchmark 7. For example, if you take IELTS test, your speaking, listening, and writing must be 5 or higher, and reading 4 or higher. If you are taking TEF Canada, then speaking 226 or higher, listening 181 or higher, reading 151 or higher, and writing 226 or higher, and so on. I have a list actually on our website, settler.ca. If you wish to know more about that list, feel free to visit this link, and it will give you the language requirements and all necessary requirements for this group. And by the way, please post your questions. When I'm done with the news, I will answer your questions. So wait, and I will answer them. So in terms of Stream A, as I mentioned, all of those, so you're a Hong Kong resident, you have valid temporary resident status in Canada, you are physically present in Canada, you meet the language requirements, your intention is to live in Canada anywhere but the province of Quebec, and also in the past 3 years, you must have finished your studies in Canada. And by finishing studies, it means that you finish your study at a Canadian school and you received either a diploma or a degree. And by diploma, it's a program that is at a college, and it is at least 2 years. Degree means bachelor's, master's, doctorate, or graduate or postgraduate diploma or certificate for at least 1 year. And also, while you were studying in Canada, you spent at least 50% of your time here inside Canada. So this is for Stream A for Hong Kong residents. For Stream B, you are still a Hong Kong resident, but you fall under the Canadian work experience group. And this means that, again, you're a Hong Kong resident, you have valid temporary resident status in Canada, you are physically present in Canada, you intend to live anywhere in Canada but the province of Quebec, you meet the language requirements, which is again CLB5, and you have completed your studies and graduated from school in or outside Canada in the past 5 years. So this time in the graduation could be outside Canada, and you have received a diploma, a graduate post certificate, or a post-secondary diploma or degree here in Canada or outside Canada. But if it's outside Canada, you need to apply for ECA to find the equivalency in Canada. What is important for this group is that you have worked in Canada for at least 12 months full-time in the past 3 years. And unfortunately, when it comes to working experience, self-employed work outside Canada, work while you are a full-time student, unemployment durations, or being on a leave or extended absence, they are not accepted. Again, as I mentioned, you can visit our website about this exciting method of immigration, which is limited to Hong Kong residents. And by the way, by Hong Kong resident, it means that you have at least one of these two passports. You have Hong Kong Special Administrative Region of People's Republic of China's passport, or you have the United Kingdom passport to a British national overseas as a person born, naturalized, or registered in Hong Kong. Having said that, your passport needs to be valid. Okay, so these are the Hong Kong ones. The second piece of news that I would like to share with you is about Indigenous people. So the government of Canada have decided that Indigenous people may use their traditional names on their documents. And specifically, when it comes to immigration documents, it could be like citizenship certificate and those kind of documents. So that's some progress in terms of reconciliation with Indigenous groups and recognizing their rights and respecting them. Hope I'm keeping my fingers crossed that we move even more forward and show more respect to Indigenous groups and, of course, accommodate them in much better ways. But at least that's some positive news that I would like to share with you. The other issue is the rumors that were going on about lifting a U.S. And Canada travel restrictions. So there were some rumors that the United States will lift those travel restrictions on June 22nd. And there were some discussions going on. And we published something about that earlier last week. But then we realized that those rumors are not gonna happen soon. Unfortunately, the travel restrictions were extended until July 21st. This means that at least until July 21st, there are many travel restrictions within the United States and Canada. That it means, simply put, if your travel to Canada is non-discretionary, then you may travel to Canada. Otherwise, you cannot from the United States. And by non-discretionary, for example, we are referring to Canadian citizens or permanent residents who want to go back home. Their travel to Canada is considered non-discretionary, or sometimes because you need to work in Canada, you want to attend a funeral or something. These are the reasons that are considered non-discretionary. In terms of travel restrictions for other nations, I would assume that this will continue for other nations as well. For the other nations, there is no deadline. So it means that it will indefinitely continue until the government of Canada decides to lift those travel restrictions. So that's what we know so far. The other issue that you would like to know is that Canada will welcome 45,000 refugees this year in 2021, despite all the restrictions. Some of those refugees will fall under Economic Mobility Pathways Pilot, or EMPP. The intention is to invite at least 500 people per year to Canada under this program. This means that if people are educated people, skilled people, and they are already identified by UNHCR as refugees, then Government of Canada will pick around 500 of them every year, and they will resettle them in Canada. So that will continue in 2021. The other one is that private sponsorship of refugee programs will continue, and there are some initiatives to assist more refugees. Again, if you're interested, we have a piece on our website. I just shared the link here. You can click the link and learn more about those initiatives about refugees. In the news, again, post your questions. I will definitely read your questions and answer them. The other thing that you need to know is about the province of Saskatchewan. So the province of Saskatchewan continued inviting people for immigration to Canada. The total number of people that they invited, if I'm not mistaken, it was about 255. So they issued 255 invitations to apply for people, and those people fall under several groups. Specifically, the last invitation occurred on June 15th, 2021, and we saw invitations under express entry and occupations in demand. For express entry, 103 people were invited, and occupations in demand, 152 people were invited. And the minimum score that they had for both is 82, which is huge, by the way. 82 is probably the highest score that we've ever seen, because so just to give you an idea about the scoring system in Saskatchewan, it's a 100-point scoring system, but about 30 points of those 100 points is for somebody who has strong association with Saskatchewan. For example, you have studied in Saskatchewan or worked in Saskatchewan. So in other words, if you're outside Canada, usually, not necessarily, the maximum number of points that you receive is 70. So if the minimum score was 82, it means that almost nobody who lived outside Canada could be invited under these programs. It was all about people who are inside Canada and most likely inside Saskatchewan. But at the end of the day, at least they invited 258 people to apply under their programs. So again, if you want to know more about the ITAs by Saskatchewan and a little bit more information about the program by Saskatchewan, I just posted the link in the chat box. You can visit that. Again, I repeat, if you want to see this, just visit settler.news, and it will take you to these links as well. Okay, the last piece of information, if you just give me 1 second, that I would like to share with you is actually, I think I shared everything. Yep. So in terms of my articles, I posted something and I'm hoping to make a video about it as well. It's about whether minor children could work in Canada or not. And so this is the link to the article if you're interested. So basically, what happened is that one of my clients called me. Their child is 16 years old, and she's on a visitor, sorry, not visitor visa, is on a visitor record in Canada. And she's permitted to work to study in Canada under Section 830 Sub 2 because her parents are on work permits here in Canada. However, she also wants to work in Canada. The question was that whether a child who is minor under 18 is allowed to work in Canada. So the simple answer to this question is no. Foreign children who are under the age of majority, they cannot work in Canada. Just briefly to let you know, the age of majority in some of provinces in Canada is 18, and in some of the provinces is 19. So in the provinces that the age of majority is 18 is Alberta, Manitoba, Saskatchewan, Ontario, Quebec, and Prince Edward Island. In the rest of provinces, the age of majority is 19. This means that as soon as you are under the age of majority, you are considered a minor child. Now, the question is that can a minor child work in Canada? Whether even if the child is a Canadian citizen or permanent resident, there are certain restrictions on working for minor children, and the restrictions include their age. So based on their age, there will be different kinds of restrictions. I give you just 2 examples. For example, in Alberta, the minimum legal age to work is 13. Now, if the child is under 12, they only may get involved with artistic work. They cannot do any kind of paid jobs in Alberta if they are under 13. Or for example, in Ontario, the minimum age is 14. But even for example, if a child is 15 or 16, they may work, but they cannot work during school hours and so on. So you need to look into the laws of each province in terms of the age limits, in terms of working in Canada. Having said that, even if a foreign national child meets the minimum age requirements of the province, they still need a work permit to work in Canada. I have posted some articles about how you can obtain a work permit. Unfortunately, the process for work permit for children is not different from work permit for adults. They need to have a valid job offer. In many cases, that job offer needs to be supported by LMIA and everything else that other adults needs to go through to receive a work permit. Again, they need to apply for a work permit, but even if they receive a work permit, they may only work if they also meet the requirements of the province in terms of age restrictions. There is only one exception to this rule for some Quebec high school students. If they are going to certain technical schools in Quebec, they may qualify to work up to 20 hours per week while they're studying in Canada. Again, I have posted all those links and information on my article. If you're interested, read that. And I hopefully will record a video on this subject. Okay, before I continue talking, I would like to go back to the questions. There are lots of questions here. Let me read the questions, answer those questions, and if there are any other no more questions and we still have time, I will talk about misrepresentation because this is a hot button issue for me. I see many people being denied entry to Canada on misrepresentation issues, so I would like to talk about it again. And by the way, while I'm going through the questions, I cannot offer immigration advice on a public forum. So all the questions that I answer they are very generic and broad answers. They are not specific to your case. So don't take this as official advice. If you want official advice from me, please book an appointment with me. My advice sessions, my consultation sessions are not free, but if they result into agreements, we deduct your payment from the retainer agreement. And it's not professional for me to answer specific questions online, especially because when we have a consultation session, I will ask all different aspects of your case, not just 1 or 2 paragraphs of explanation. And then based on that, we decide where to go and what to do. But regardless, I will go through these questions and I try to give you broad answers to those questions, but no official advice here. Okay, so the first question or set of questions is from Minu Aurora. So hi, Minu. So let me read all of your paragraphs and then we go back. I and my wife got PR in 2006. However, we could not stay in Canada for 2 years out of 5 years to as required, since we had to come back to India to take care of my old parents who were unwell. Our PR got expired in 2011. In the meantime, our son was born in India. Now we want to go back to Canada and get PR. What should we do? Is there any provision to file our case for appeal or reconsideration? Is there any provision to file our case for appeal? Okay, the same question. Okay, so let me answer. As I mentioned, I cannot talk about your specific case, but generally speaking, first of all, for those of you who are not familiar with the concept of permanent residency, let me briefly explain. When you immigrate to Canada, upon landing in Canada, your first landing, you become a permanent resident of Canada, and you receive a piece of paper called COPR, or Confirmation of Permanent Resident, which indicates the day that you became a permanent resident of Canada. Nowadays, because of coronavirus, for certain people who are inside Canada, they receive COPR through email. But in the past, everybody received it by mail, and you had to go to a port of entry to validate it. Regardless of that, the COPR says which day you became a permanent resident of Canada. From that day, if you count every 5 years, you need to remain in Canada at least 40% of the time. So that, in other words, out of every 5 years, you need to spend at least 730 days inside Canada. This is called residency obligation. Residency obligation means either you are physically present in Canada, or if you are not physically present in Canada, under the law, you are considered a resident of Canada. An example is that, let's say I come here and RBC hires me, which is the largest bank in Canada, and then they have a spot available in Dubai, and they transfer me to the Dubai branch to work for RBC, which is a Canadian company. In this situation, the days that I spent in Dubai is also considered towards my residency obligation. You have to be very careful with those alternatives, because those alternatives, people have abused them over the years, and the immigration authorities are aware to those abuses, like creating a fake, not necessarily fake, but a brand new company, and then your own company sends you outside Canada. They are aware of those. They don't buy into those claims, etc. So if somebody doesn't meet the residency obligations, what will happen? Look, permanent resident of Canada is considered permanent resident, so it is permanent. However, when you are outside Canada and you do not meet the residency obligations, then your PR card is expired. You cannot travel back to Canada. And to resolve that issue, you need to apply for something called a PRTD, or Permanent Resident Travel Document. I have an article about PRTD, so I just post the link here in case that you are interested to know more. about PRTD. So PRTD is a piece of like a visa counterfoil that they attach into your passport, and then with the help of that, you can travel back to Canada. And then when you enter Canada, you apply for PR card. If you are inside Canada and you do not meet the residency obligations, you can apply for a PR card, but they won't issue the PR card. So if you do not meet the residency obligations, then at that point, an officer could cancel your permanent residency. That's when you lose your permanent residence. So if you came to Canada in 2006, you never went back to Canada since 2011 or sooner, and your PR cards are expired, but you have had no interactions with immigration authorities, you're still a permanent resident of Canada. Having said that, the problem is that you cannot travel to Canada because your PR card is expired. The only way that you can travel to Canada is by going to the United States and use your private car to travel to Canada by land. But even in that situation, at the port of entry, although they will allow you inside Canada, a border services officer will find out that you are inadmissible to Canada because you didn't meet the residency obligations. And this is under Section 41 sub B of the Act. And what they will do, they will interview you and they will issue you a removal order, which is a departure order. Or if you're outside Canada and you apply for a PRTD, you lose your permanent residence by the decision of an immigration officer. So this is by default what will happen to somebody who doesn't meet the residency obligations. Can you fight back? Yes. Under Section 28 sub 2 of the Immigration Act, there are some provisions in terms of humanitarian and compassionate considerations, especially the best interest of a child, and that they will look into that. And if they are convinced that there are enough HNC reasons, humanitarian reasons, then they will allow you to enter Canada. This could be initiated when you are submitting your PRTD application or when you are going through your interview with a CBSA officer or IRCC officer at the port of entry. Or you could file for an appeal of cancellation of your permanent residence to Immigration Appeal Division. Many of my clients, they come from that background. And of course, issues like my parents were sick, etc. These are some things that people always bring up. It needs to be extremely severe for them to consider those situations. They also look into many different aspects of that application. These are defined especially under an interesting case that I use a lot. It's called Ali versus Canada. As I mentioned, I've had many clients under this program. If you want me to see if there are any chances for you, you can book an appointment with me. I looked into that, and I will tell you what are our chances in terms of winning the case if we take this through the process of PRTD and eventually the court. But I try to be as brief as possible. Now I know I wasn't that brief. So does pre-diabetic prevents you? So this question is from Aijnab Romero. Does pre-diabetic prevents you to get permanent residency? So obviously, again, it depends on the severity of the situation. But my understanding is that people who are pre-diabetic, especially if it's type 2, they usually they just need to change their diets. Or in certain cases, the officer may, the doctor may, for example, prescribe metformin or something similar to that. In those situations, we are not talking about excessive demand. It's not a huge expenditure if somebody is pre-diabetic. Even with the diabetes, most diabetes cases, they do not cause inadmissibility to Canada under excessive demand. Now, the excessive demand says that if the expenditure on your disease in Canada is more than $21,000 per year, or roughly more than $103,000-$4,000 per per 5 years, then in that situation, you could become inadmissible to Canada. If the expenditure on your disease is less than that, then you are not inadmissible to Canada. Even with those situations that the spending is more than $100,000 per 5 years, there are some ways that we can handle the situation under HNC, under TRP. There are certain situations that we could negotiate the expenditures and reduce the expenditures below the threshold. We can get advice from doctors to assist with that. So if somebody encounters medical inadmissibility to Canada, you can talk to me. I have some experience with that. I have written articles. I have attended courses about this issue, and I think I have good grasp of medical inadmissibility. But generally speaking, again, I cannot offer you immigration advice for two major reasons. This is very brief what you have shared with me. Second one, I'm not a doctor. I need to receive reports from doctors to evaluate them and see how dangerous this situation could be. But generally speaking, I would say it's very unlikely for diabetes, or even for diabetes, especially diabetes type 2, that we are in a situation that the person is inadmissible to Canada, unless the diabetes type 2 is in such a way that it has damaged organs and attacked, different parts of the body, etc. That could potentially cause problem. But again, it depends on the amount of expenditure, because diabetes, it's not a contagious disease, so it doesn't make you inadmissible because of endangering the safety of Canadians. It's all about excessive demand. Okay, so the next question is from Mamta Solanki about new caregivers from Israel to Canada immigration. So the caregiver program is not limited to a specific nation. It's basically for every nation. We currently have two pilots, or actually it's defined under one pilot. It's for home caregivers and home child caregivers. So home child caregivers are people who take care of children. They have experience in that field. They hold at least a college diploma, at least 1 year of education at college level. They need to take English test and CLB5 or higher, similar to the results I shared about Hong Kong residents. And they need to have a job offer from a Canadian employer that they say, we want you to take care of our child. In that situation, you can apply through an office in Edmonton, CPC Edmonton. What they will do is that they will issue a restricted open work permit. It means that you can come to Canada, work for an employer for 2 years, or multiple employers, but work as a home child caregiver for 2 years. And then after 24 months of work experience in Canada, you qualify for permanent residence. It's just they make you a permanent resident of Canada. So that's option number one. Option number two is for home support caregivers. By the way, for the home child caregiver, foster parents are not accepted. For the second one is that you are taking care of an ill person or elderly, somebody who needs care. For example, their food is given to them, their medication is administered to them, those kind of things. And the same process. Again, you need to have a job offer. So the important thing about caregiver pilot is that you need to have a job offer. You have a job offer, but despite that job offer, you will receive an open restricted work permit. It means that when you come to Canada, you may work for the same employer that offered you the job, or work for other employers. And then after 2 years of working in Canada, you qualify for permanent resident. There are some caps for these programs. For example, for home child caregiver, the cap is 2,175 or something, or 2,700. Anyways, that cap has reached this year, so you cannot apply under home child caregiver pilot, but for home support, yes, worker, you can apply. But they will reopen accepting applications under home child caregiver in January 2022. So if you have a job offer, you can go through all the process, prepare your documents, etc. now, and then in January when we open it, you can apply. Actually, I have clients that they qualify and we want to apply for them in January. So that's a brief information about that. Okay, so the next one is from Salam. How much private sponsorship refugees applications take? And NY Abu Dhabi visa office not processing the applications. So first of all, for private sponsorship refugees, nobody should charge you anything. When we are talking about refugees, we're talking about a humanitarian activity, and the expectation that somebody charges a refugee is, to be frank with you, it's heinous. And actually, we had an immigration consultant that they did this a few years ago. That, to the best of my knowledge, that the license of that immigration consultant was revoked, and there was a huge backlash in the news about this issue. But if somebody files for refugee as UNHCR, they are approved and they have private sponsors. By private sponsors, usually we are talking about a group of 5 Canadians that they accept your expenses in the first year of coming to Canada. In that situation, the government will resettle the refugee from that country, now in this case from UAE to Canada. The processing was supposed to be less than the processing of regular kind of applications, but unfortunately in recent years we have seen longer processing times for this group, and sometimes it could take 2, 3, 4 years for them to be processed. In terms of the visa office in Abu Dhabi, you are right. Unfortunately, the visa office in Abu Dhabi, for some reason, they are not working. They are extremely slow. I do have some applications that are stuck in that visa office, and no matter how many times we follow up with them, they do not process the applications. Of course, they associate that with coronavirus, but it's weird because, to the best of my knowledge, United Arab Emirates is #1 country in terms of administering the vaccines. So why we're still not seeing any movements from Abu Dhabi, I don't know. And I have tried to be communicative with them and try to encourage them to process our applications, but nothing. And actually, it wasn't even after coronavirus that we saw slowdown in visa office in Abu Dhabi. Even before coronavirus, we had cases that they were stuck in their office and they were slowly being processed. So for some reason, that office is not very active, but especially it was exacerbated by the situation that caused by coronavirus. Okay, where am I? I think I lost the questions. Okay, so the next question is that Madhu Sachdeva. Sorry if I didn't pronounce it correctly. So Madhu Sachdeva. I hope I pronounced your name correctly. What is your retainership fee for, and what services do you provide against it? Okay, so the retainer agreement with our company and me, it varies. It could be from a few $100s to several $1,000s, and it all depends on the services that we offer, the options that you pick. I give you an example. For example, for IMPC 11, which is work permit for entrepreneurs in Canada, that involves, business registration, business plan. It's a very complex process. Our fees are way higher than spousal sponsorship applications. So it all depends on the kind of or the nature of the application that you are picking, and also the services that you expect from us. So we clearly mention those on the retainer agreement, what kind of services we offer, and then how much we expect to be paid in professional fees. And we even mention the government fees and other fees, so you clearly know how much you will be charged. The way that we handle this, there will be some interviews in the beginning, exchange of documents, those kind of things. And when we reach a point that we are convinced that, we would like to offer our services to you, and you are convinced that you would like to hire us, in that situation, we will send you a proposal with all the list of services that we offer and the professional fees and other fees. Then if you're happy with those, then you will send us your documents and we will prepare the retainer agreement. I always share the retainer agreement upfront with my clients. I gave them enough time to consult with another lawyer or somebody else to make sure that this is really what they want to do. They want to hire us. And that's when we sign the agreement and then we move forward. Okay, so the next question, I need to speed up. Oh my God, there are so many questions. Okay, so the next one is Manorajan Avasti, sorry. So Manorajan Awasti says, can an applicant be declared inadmissible if he is facing trial in his country for libel? Will his PR be considered after judgment? He may be acquitted. So generally, so this is a very generic, because inadmissibility issues are very complex. But generally speaking, libel and slander in Canada, in most cases, it is not a criminal offense. It's a civil offense. So I would suspect that in that situation, a libel issue in your home country makes you inadmissible to Canada. Having said that, remember, I'm not a criminal lawyer. Whenever I deal with a criminal inadmissibility, there is actually a very good lawyer that I work with him. I get your information, I share it with that criminal lawyer, ask them to find the equivalency in the Canadian law, and then based on that, I can tell you whether you are inadmissible to Canada or not. But if somebody has committed offenses outside Canada and that person has not received a conviction yet, despite that, that person could become inadmissible to Canada. And it's a sad story, but it's true. The reason that this happens is that, of course, somebody may say that you are innocent unless found guilty. The problem here is that the standard of proof for criminal offenses is beyond reasonable doubt. However, for immigration, it's reasonableness. It means that if you show the information to a reasonable person, they say, oh yeah, this person is guilty. And that's why we've had cases that a person was charged outside Canada, excuse me, that person was charged outside Canada. Despite that, the person became inadmissible to Canada. So if you are facing issues outside Canada, I highly recommend that get in touch with me or another professional person in the field of inadmissibility to Canada. We will review your case and will tell you that whether you are facing issues or not, or whether it's okay. I had a case that this person had received 2 months prison time in another country. And then we realized that the offense that he received the prison time for is not an offense inside Canada. And because of that, we were able to apply for them for immigration, because my client was not inadmissible to Canada despite facing a 2 months prison time outside Canada. So we need to look into the equivalency of those offenses inside Canada. If something happens outside Canada and it's considered an offense, but inside Canada it's not a criminal offense, then it doesn't make you inadmissible to Canada. But if in both that country and inside Canada it's considered a criminal offense, yes, that causes trouble. Now, I just posted a link to an article I posted about criminal charges outside Canada and how they make you inadmissible. You can also read that article. Okay, so the next question is by Madhu Sachdev. If 3 clients were to hire your services, that discount would offer Again, Mathud, definitely we will look into the applications, and yeah, obviously, if there are multiple clients, we could make different arrangements for them, obviously. So can an applicant be declared inadmissible? Okay, we talked about this. So the next question is from Ashish Sharma. Sir, my brother came to Canada on study visa, but he couldn't complete his studies. Now his visa is expired, and this time he got married with Canadian citizens, so he can apply sponsorship. I think the same question has been repeated multiple times, 10 times. Why you have repeated that question 10 times, Ashish? Oh my God. Just post your questions once. I will go through them. It just, confuses me and others. So I have an article about residency requirements for in Canada class applicants. So let me locate this article because it's an interesting subject. So I post the link, but I won't post it 10 times like you posted your questions 10 times, but I post it here, you can read it. But generally speaking, under certain circumstances, we have a public policy that was initially posted in 2005. We have many court cases that they have received that public policy since they have considered that public policy since 2005. And they all emphasize on the fact that when somebody is inside Canada under certain circumstances, despite overstaying in Canada, despite not having status in Canada, they may still continue through the process of inland spousal sponsorship. So the simple answer is that the officers will not refuse the permanent resident application simply because the application was basically the applicant does not have a status in Canada. So that's the very brief answer to your question. But despite that, this doesn't prevent CBSA from removing a person from Canada. So in other words, if CBSA finds out that a person is infraction of Section 41A of the Act, which is in this case, remaining in Canada without permission, then in those situations, the person may face a removal order from Canada, and even CBSA may actually enforce that removal order from Canada, which jeopardizes the whole sponsorship application. That's why the best way to handle this is that despite that we can apply for inland spousal sponsorship despite not having the status, is to also try to resolve that issue of not having status in Canada. And I've had clients in the past under inland spousal sponsorship applications that we try to resolve these issues, and they received, some of them, they have received their permanent residency already. Some of them, they are in the process. And I think that there are ways to handle these cases, but honestly, this is a complicated case. I highly recommend that you get in touch with a professional and try to retain them to help you with that. Again, on the face of it, you can apply for inland spousal sponsorship without having status in Canada. But beyond that, there are potential complications surrounding it that you need to take proactive steps before even considering the application for permanent residency. So can an applicant be declared inadmissible if he is facing trial? Okay, we already answered this question. So again, please do not repeat your questions. It's useless. So good morning. Oh, Andy. Hello, Andy. So Annie, hola. Greetings from Punta Cana. I hope you're enjoying your time over there. Okay, so the next question is from Mijer Gallard, and I hope I pronounced your name correctly. Hello, is this true that if you're vaccinated by Sinovac, you can't enter Canada? So basically, Canada does not have a vaccination policy yet. Okay, as we speak, they do not have a vaccination policy yet, but in the future, they are gradually removing travel restrictions for people who are vaccinated. So the rumor says that those travel restrictions will be removed for people who have received those vaccines that are already approved inside Canada. And to the best of my knowledge, only 4 vaccines have been approved inside Canada. That's Pfizer, BioNTech, the other one is Moderna, the other one is AstraZeneca, and the other one is Johnson & Johnson. So these are the 4 vaccines that they are approved by Health Canada. This means that if you have received 2 shots of these vaccines, assuming that they eventually issue a vaccine policy, we don't have that vaccine policy yet, then they will remove restrictions for these people. Now, for other vaccines, right now, I don't think they want to remove restrictions for those people who received other kinds of vaccines. Having said that, they are developing a vaccine policy. So we don't know the details yet. They might come with some, alternatives for those people that I'm not aware of it. So let's wait and see how this will unfold. It's very early to come up with definite answers. Even if you ask this question from the Prime Minister of Canada or health authorities of Canada, I don't know. I don't think they have all the answers to these questions. Okay, so the next question. So Manorajan Avashti says the equivalency is section 298 and 300 under Canadian Criminal Code. Okay, so if we do have a criminal code in Canada, then that could be problematic. But again, if you want the exact answer to your question, I need to see the document. So you can book a consultation session and let me look at that. So the next one is Rajiv. Yugiswaran, I applied the spouse sponsor under humanitarian category. They refused under undeclared family member. Isn't worth to wait. So again, I don't know what's your question, but I'm sorry if you were refused. And by undeclared family members, actually we have a policy that certain undeclared family members, they could be sponsored again until September of this year. So that policy is still in effect. So maybe you can get in touch with us, share with us what's the problem, and we might be able to help you. Again, I don't know what was that situation about undeclared family members. I have an article about undeclared family members. You can read that as well, but if you want official advice, you can get in touch with me. So the next question by Andy is that how a child of a Canadian citizen born abroad can enter Canada before getting the Canadian citizenship certificate. Andy, I don't think that would be an option because they need to resolve their citizenship issue. Because if you're a Canadian citizen, you cannot apply for a travel document. Having said that, they may get in touch with the visa office in their home country and ask for advice. They might have some solutions. Sometimes they do have things, that we are not aware of. But generally speaking, the answer is that they will wait for the Canadian citizenship to be resolved. And nowadays, issuance of citizenship certificates takes forever. It's such a time-consuming process right now. It didn't used to be. It was a 5 months processing time, but my last certification that was issued, it took them more than 18 months to issue it. So my paper-based PR application, self-employed persons, filmmaker. So this one is from Riz Hale. My paper-based PR application, self-employed persons, filmmaker 5131 is in process, applied April 2020, temporary AOR January 2021. Can I still apply C11 IMP temporary work permit as self-employed dual intent? So the simple answer, again, I'm not offering immigration advice to you, but the simple answer is that this falls under dual intent and or section 22 sub 2 of the Immigration Act. And the dual intent says that an immigration officer cannot refuse your temporary status application because you have a permanent resident application. So in other words, if you already have a federal self-employed class application going on, you can apply for a work permit. As at the same time, they cannot refuse your work permit because you apply for permanent residence. Obviously, they could refuse it under other areas, but not because of that. I've had many self-employed clients that we at the same time applied for their work permits under IMPC 11 after submitting their federal self-employed application. Actually, the last one just entered Canada about 10 days ago. He's still going through the quarantine process. So it is a possibility. I've had clients in the past that I applied for them, and I've had success stories with them, and of course failures, but none of them, even those people who got failed, they were not refused because of their dual intent. And of course, when I apply for my clients, I clearly mention that this is a dual intent case. I include the provisions of the law and to convince the officer that we are truthful, we are open, this is the situation that we are going through. And I would say I've had very good success stories with this kind of applications. If you're interested, you can get in touch with us. We can review your case to see if you qualify for IMPC 11. And if, in our opinion, we qualify, you can hire us, or at least you have a consultation session to see if this is the way to go. Okay, so we're almost out of time. So let me answer these last two questions. So the other question is Shamil Ibrahim. Hi, I repost my question as you missed it earlier, as it was among duplicated questions of some others. Oh, sorry about that. My queue is when student visa is rejected once, can't we apply a subsequent visa? Thanks. So the simple answer is that if your temporary resident visa, so whether it is temporary resident visa, work permit application, study permit application, is refused, and the refusal is not based on inadmissibility. So in other words, the person is not inadmissible to Canada. For example, they didn't misrepresent, or they are not inadmissible for medical reasons, etc. In that situation, you can apply the very next day. It's okay. I mean, a person who is refused a study permit application or a work permit application or a temporary resident visa application, upon refusal, they may apply almost immediately. Nobody prevents you from application. Obviously, you need to address the issues that the officer was concerned about and then apply again, because what's the use of applying again without addressing those? So that's why we usually, if somebody comes to us and says that my study permit application was refused, the first thing that I do, I put an ATIP request. I receive the officer's notes. I analyze the officer's notes, and based on that, we devise a plan as to how to move forward. I had a case of a gentleman from Egypt that was refused. His study permit was refused. He hired our team a few months ago, and then we got the ATIP request, and we prepared another application for him. And guess what? He received his study permit about 3 weeks ago. So I'm not saying that if you look at an officer's notes and apply, they will definitely approve your study permit. No, it's not guaranteed. But at least if we have enough information, then we can apply properly. We actually, if you're interested in hiring us to help you with the officer's notes, our services are very cheap. We actually charge $100 US to get the officer's notes for you and analyzing it and give you a report. So if you're interested, this is the link. Even if you Google immigration officers notes, my article is #1 on Google. But if you click on this link, you can pay the fee. We'll do the research for you. We'll give you the results. If after receiving the results, you can continue yourself. You can hire us. It's up to you. Okay. Where is it? So the next question is my wife was received verbal job offer from 2 separate employees, one from Sask, other from Quebec. Which option is faster and convenient? Communication, spec, knock. Okay, obviously I cannot answer that question because the issue is, first of all, when it comes to Quebec, the issue is with the federal self-employed class is that your application is for federal, and it means that your intention is to reside anywhere but the province of Quebec. And if you accept the job offer, or your wife accepts the job offer in Quebec, the question is that why on earth you are saying to us that you want to reside outside Quebec? So there needs to be several justifications in that front. In terms of which one is processed faster, nobody knows. I mean, I cannot come up with something and tell you something false, and then you get disappointed. It takes time. The processing of LMI applications, the processing of work permit applications always fluctuated significantly. But when it comes to after COVID-19 or during COVID-19 pandemic, it's even worse. So nobody can answer that question to you. And also, I don't know your nationality. I don't know the nature of the job. There are so many questions that I don't know. If you are serious about knowing the answer, you can book a consultation session with me. We can go through that and review all those questions. Okay, so how much time it takes to get the PR card after getting ECO PR? So, I mean, in theory, it should be around 2 weeks nowadays. In reality, I've seen people that they submitted their photos, and it's been like 6 weeks and they haven't received it. 8 weeks, they haven't received it. So unfortunately, even with the inside Canada offices, it doesn't work that way. In the past, we submitted all the requests to Sydney, Nova Scotia. Sydney is not working, so a local office will process that for you. Like, for example, Etobicoke here in Toronto, and unfortunately, nobody can predict it, but it shouldn't go beyond 8 weeks. And in most cases, it's 2 weeks, 3 weeks. In some cases, it could go beyond 1 month. It's very likely it goes beyond 8 weeks. You are very unlucky if it goes beyond 1 week, 8 weeks. And if it goes past like 6 weeks or so, you can actually call them, follow up, see what's going on. Okay, so we already passed our 1 hour, and I think I answered all the questions. Let me make sure. Yes. So thank you very much for attending this session. Again, I introduced myself. My name is Al Parsai. I'm a regulated Canadian immigration consultant. I'm a college professor at Ashton College. I teach immigration courses, both advanced courses for other immigration consultants and regular courses for people who want to become immigration consultants. I also teach CPD courses for people who want to advance their education. I'm also an adjunct professor at Queen's University, and I'm the author of 88 Tips on Immigration to Canada. This is my book. You can purchase it by visiting any Amazon websites or visiting 88tips.ca. And also, I have 10 years of experience as an immigration consultant. I have dealt with all different kinds of immigration applications. Can you imagine? You can imagine from 50 plus different countries so far. If you would like to get in touch with us, visit settler.ca. If you want to have the latest updates about immigration to Canada, visit settler.news. And I will be live on YouTube every Sunday at 10 a.m. EST, which is the Eastern Standard Time or Toronto time. For 1 hour, I will hopefully answer all your questions like today. And also, I will publish videos on YouTube. Please subscribe to our channel, enable notifications. And on Instagram on Fridays at 10 a.m. EST, I have sessions in Farsi language. Thank you again, and see you next week.